Did you know that California leads the nation in DUI arrests? Between the police, sheriff, and the California Highway Patrol, there's about 200,000 DUI arrests each year in California. So if you've been arrested for driving under the influence, you're definitely not alone. At the same time, as a lawyer who's concentrated on DUI cases for 2 decades now, I know that there's no comfort in numbers, that the only case that matters to you is yours. The first thing to know following a DUI arrest is that time is not on your side. One DUI arrest actually triggers 2 different cases to be fought. One's with the court, the other is with the DMV, and there are strict time limits to be honored, or else your driving privileges will automatically be suspended. The first case is the court case, and that's where you face a criminal conviction, being placed on probation, possible jail time, fines, DUI classes, and even being ordered to have an ignition interlock device installed in any car that you drive. For those of you that don't know, an ignition interlock is a breathalyzer that installs in your car and prevents it from starting unless you first blow into it to show that you're alcohol-free. The second case is the DMV case, and this is the one that often burns people in the fine print. When someone's arrested for DUI anywhere in California, the police will give them a pink piece of paper that's called a Notice of Administrative Per Se Action and Temporary License. About 2/3 of the way down the page, in the teeny tiny fine print, it says that you've got only 10 days from the date of your arrest to request a special hearing with the DMV, or your license will automatically be suspended 30 days after the arrest. All that needs to be done to avoid that automatic suspension is to make a request for a hearing. But there are some important tactical reasons why you may want a lawyer to do that for you. And if you miss that 10-day window, the DMV's automatic suspension machine kicks in. The length of the suspension will vary depending on whether you're over 21 or under 21, whether it's a first offense or a multiple offense, and whether you took or refused a chemical test at the time of your arrest. But the thing that often hurts people is missing that 10-day deadline. Since the suspension can run from a minimum of 4 months up to several years or even a lifetime, this can be a really big deal. This is just one of the reasons that it's so very important that if you've been arrested for a DUI, that you talk to a lawyer right away. And for those of you who came to California on business or pleasure and have a license from another state, you can't afford to miss this deadline either. There's something called the Interstate Driver's License Compact, which allows each state to share information. And if your license gets suspended from a DUI in California because you missed that 10-day window here, this will get reported to your home state, and they will suspend you there too until you fix things up in California. There is so much to talk about in the world of DUI defense. So if you've been arrested, I invite you to please watch some of my other videos, or better yet, just call us so we can talk about the specifics of your DUI case. Just know that there's many ways to successfully fight these cases, that there's more than 50 ways breath and blood tests can be wrong. So there is hope, no matter what result that machine may have spit out. But you've got to act fast. On behalf of everybody here at the Kavinoky Law Firm, I hope this helps.